In this video, we're going to continue with our discussion about trustee powers, and specifically we're going to be talking about the delegation of powers. And this is going to be the final video before I move on to talking about other types of powers. We've already looked at the powers of investment, and we're going to talk about the powers to maintain, the powers to advance, and some other miscellaneous powers. Okay, so as a general rule, trustees may delegate their powers of investment to another. The old rule was that a person with a fiduciary duty does not fulfill it if he delegates it to someone else. The trustee remains liable for their default. So traditionally, you could not delegate the power to invest, and if you did, you would be in breach of your responsibility. But now you can. But even if you do delegate that power to invest, you are still liable as a trustee for default. In other words, you are still responsible for whatever the consequences are. And this from the old law itself. Turner and Corney and Lord Langdale from this case said that I must observe that trustees who take on themselves the management of property for the benefit of others have no right to shift their duty on other persons, and if they employ an agent, they remain subject to responsibility towards their cestui trust for whom they undertake the duty. So this is the old rule, which says that you cannot delegate the power to invest, and if you did so, you would be in breach of that responsibility, of your responsibility as a trustee. And as I mentioned in the previous slide, this rule has now been changed, as we can see in the case of Spate and Gaunt from 1882. And in this case, it was held that a trustee should act as an ordinary prudent man of business, and that to impose a more stringent standard on them would prevent anyone from acting as a trustee. Where the delegation of functions to professional advisors was acceptable business practice, the trustee could delegate. For example, they were entitled to delegate administrative and legal duties to a solicitor. So, where the delegation of power was what an ordinary prudent man of business would do in that it would be best for the trust fund, then that is okay. For example, to delegate administrative and legal duties to a solicitor. And this really does make sense because a solicitor is good at those things and a trustee simply might not be. However, in Fry and Tapson from 1884, the trustees had delegated the choice of a valuer to a solicitor. And in this case, the choosing of valuers was not a normal business function of a solicitor, so the trustees were held liable. So this case of Fry and Tapson says you cannot delegate the powers to just anyone. So if the person you delegate to doesn't normally do the function you have delegated to them, then you will be in breach. And in Leroyd and Whiteley from 1887, in this case, the trustees relied on a valuation of a brickmaking business. The House of Lords held that they were entitled to rely on advice by skilled persons in areas where they had no expertise, but this did not release them from the duty to use their own judgment. In particular, they could rely on the valuer as to the value of the land and buildings, but not as to whether the investment was a good one. So the trustees here knew nothing about brickmaking and decided they should find someone who does. But this did not release them from their duty to use their own judgment. So you delegate the power to give you the information, facts, so you can make a decision. So they're delegating the power about brickmaking. They want to find out some more information about it, but that is to help you make a decision as a trustee. Ultimately, it is you, the trustee, that needs to make the decision, and not the person who you gave responsibility to, to provide that information. For example, the valuer in this situation. Now, clearly, the management of large sums of money is something that requires a degree of knowledge and skill, which trustees of a family settlement may not possess. Trustees are entitled to rely on professional skill and advice and to delegate the day-to-day management of the trust property. So the court recognises in this case that trustees haven't got knowledge and skill on everything, so they can rely on the skill and advice from others to make their decisions when necessary. And this area is now governed by the Trustee Act from 2000, which from part 4 of that act. And this gives a general power to delegate powers of investments to agents. Section 22 of the Act imposes a duty of review on the trustees, which means that they must keep any delegation of their powers under review. Section 23 provides that a trustee will not be liable for the acts of a person delegated to carry out investments, as long as they have not failed in their duty of care in appointing an agent and keeping the delegation under review. So the Trustee Act gives a general power to delegate. You're still liable, but it does give you that power. And Section 23 says, you cannot hire a solicitor as a valuer because this is not what they normally do. So long as you appoint them for their proper function, then you are okay. So that was a really quick video then about how trustees can delegate their particular powers. And I think that wraps up the whole idea of the power of investment and the general powers of a trustee quite nicely. But I do want to now talk about in the next few videos about the other powers, including the power to maintain, the power to advance, and other miscellaneous powers. If you do have any questions about this video, then please leave a comment below and I'll get straight back to you. If you enjoyed the video, then please leave it a thumbs up and subscribe to my channel. Thank you very much for watching.